All right, let's get started.
Good evening, everyone. Welcome to the Citizen Planning 101 workshop. This is the third in a series of workshops being sponsored by the Van Buren Charitable Foundation and being hosted by ALT and GrowSmart Rhode Island jointly. I just would like to thank the Van Buren Charitable Foundation for funding this set of workshops. The intent of this is to help our communities get more engaged in the land use process by learning how that process actually works. This workshop will be recorded tonight. The recording will be available afterwards on ALT's website, and I think GrowSmart Rhode Island's website, correct? I think. And if you have any questions during the presentation, you can post your questions in the Q&A, not the chat. Q&A is better. And then there will be time at the end to actually answer the questions that are posted. At this point, we wanted to start with going over the plan that ALT did, the development threat analysis that the Aquidneck Land Trust did, that really kind of was the genesis for doing these workshops. And Alex Schuman, our conservation director, will provide a brief summary of what the findings of that report were. Thanks, Alex.
Great, I'm just gonna get my screen up. All right, can you see that?
Yes.
Okay. Thanks, Chuck. So I'm going to share sort of an overview, 10-minute overview of the Aquidneck Island Development Impact Analysis ALT completed a few years ago with Suzaki Associates, which is a large consulting firm out of the Boston area. The full report will be available, I should say, on our website. I'll share the link. So I'm just sort of doing a bird's eye level here, showing some key points. But if you're really interested in it, we go into all the methods, all the results in great detail, lots of great images and maps in that report, and I'll share the link once I finish talking here. Right. So the goal of this project was to understand the potential impacts of future development on Aquidneck Island, plain and simple. And we did that by looking at two different scenarios. The first was basically a status quo scenario. So we looked at development in the past, looked at the current trends and what that might look like by 2050, and we called that scenario one. The second was a second scenario that we looked at that really looked at if the island chose a different path where conservation is prioritized, and we still accommodated the same growth because we need to grow. Development will happen, but we redirected those development pressures in a different way. And that's, we called that scenario two, plan and protect. So I'll refer to both of those over the next few minutes. Again, scenario one is a status quo, and scenario two is this sort of smart growth conservation-based vision. The way we did the analysis, we first looked at all the parcels on Aquidneck Island throughout the three towns, and we built a model. We looked at the land use and the current zoning, and then we did a build out of the island in each of these scenarios. Once we had those mapped out, we looked at what how they looked across the landscape on the island. When we had that, we could then figure out if the towns were built out in this way, what would be the impacts to natural resources, what would be the impacts to tax revenue, the way of life here, those sorts of impacts. And we, of course, pulled out some key findings from the analysis. So one of the key things to think about to start off was figuring out what is going to be the future development demand on the island. And to do that as a standard, we looked at what development has been like in the past. So what you're looking at here is the number of units built since 1980 to 2017. And that was 6,200 units across the island, or around 165 per year. The interesting thing here, and a question we have gotten a few times when we've done this presentation, is why are we having so many units being built when the population has basically stayed steady since 1980, around 60,000 residents? And the reason for that is really threefold. The first and probably most obvious is just that there are a lot of second homes here. There's a lot of second home demand. So more houses are being built. They're not necessarily year-round residents that are contributing to the year-round population numbers. The second is sort of the Airbnb effect, which, Airbnb takes some housing stock off the market. And the third is kind of a demographic trend where we see household sizes just decreased a little bit with time and over the years. And when you have lesser people in each household, you need more homes to support the same amount of people. So those are probably the reasons why units continue to be built despite the flat population. One of the key points here is that rate of 165 per year, because that's what we projected out as the demand with each year over to 2050. So one of the first things we did was just gather existing conditions on the island. We looked at all the parcels. We built a really comprehensive land use layer, looked at the zoning, and just some of the key highlights of that. Around 50% of the open space on the island is unrestricted and susceptible to development. And of that 50%, 80% is zoned residential, primarily medium and low density residential. So what that means is most of the development pressure here, based on current zoning, is sort of residential subdivision. Once we had those existing conditions, we began the build-out analysis. So this is what this looks like across the landscape. If you know your aerial photography, this is looking north of West Main Road. And basically, when you look at the parcels and you look at the zoning on each, you can project what, if built out, how many number of homes each of those parcels can support. So what we found by 2050, all of the open space on the island was either gone, built out, or it was protected under this scenario, under the status quo. And what that looks like, just some examples of farmland in Portsmouth that are zoned residential. Farms like this are turning into typical residential subdivisions. And that really was sort of the gist of scenario one. We've lost all the open space by 2050. Scenario two, which accommodates the same exact amount of growth. And that's really the key point here. In both scenarios, we're accounting for that 165 new units per year. What we did was we densified certain areas. And you can see on the map here, there's some higher density on scenario two here versus scenario one. And when you do that, you're able to save more land because you're accommodating the same amount of units in certain parcels, but being able to save a lot of more land overall. And you can kind of just see the difference here in the new red buildings. And part of what we did in the scenario two projection as well was we looked at some parcels as redevelopment projects. So here's just an example of a sort of an old-fashioned strip mall development, and something like this in scenario two in some cases was turned into more of a modern mixed-use town center, which accommodates residential use, commercial use, is walkable, and you get more residential units and more commercial use in a smaller area than under the current zoning. So when you compare the two scenarios, these maps do a pretty striking job, I think. Red on this is, of course, a map of Aquidneck Island. The red areas are areas where that have been lost to development. So in the status quo scenario, you can see quite a few of the quite a bit of Aquidneck Island is lost. Scenario 2, which accommodates the same number of units and development, much less open space is lost. And I think one of the important points here is really the country as a whole, but particularly Aquidneck Island, there's certainly a housing shortage, in particular workforce housing. And one of the key findings, I think, is that saving open space and allowing for development aren't mutually exclusive things. They can both happen at the same time. In this second scenario that has a smart growth vision, we're allowing for growth and more housing, the same amount of housing units as scenario 1, but we're also saving far more land. So when you look at what the total numbers are, under the status quo, we would lose around 3,000 acres of open space. But in the second scenario, plan and protect, we only lose 900. That difference of 2,100 is pretty significant for the island. That's almost 10% of Aquidneck Island. So once we had the build out done, we started looking at impacts. I'm just going to highlight a couple. We have far more in the report. One of the things I think many of us know on Aquidneck Island, the drinking water we drink, some folks have wells, but the majority of it is from surface water reservoirs on the island. There are 7 throughout Middletown and Portsmouth, and a couple more across the Sconnet River. And what we found, unsurprisingly, is in the status quo scenario, the impacts of those reservoirs was much more significant. More impervious surface in the watersheds, more suspended solids, nutrients like nitrogen and phosphorus, which have impacts on the source waters. The other piece that's so important to Portsmouth is, of course, our agricultural heritage. For a number of reasons, farms contribute to the economy, they contribute to scenic vistas, they're important open spaces, parts of the community. With climate change, local farms are going to become more and more important, I think, as growing conditions are harder out west. And what we found in scenario 1, we lost 3/4 of the existing unprotected farmland on the island. When you compare that to the conservation focused scenario, we only lose 22% of the farmland. And finally, one of the big ones, of course, is tax revenue to consider. And when our consultants looked at this, they discovered actually under the scenario 2, plan and protect, we actually had an 8.4% higher tax revenue increase over the time period. And that's because mixed use developments, of which there were proposed in scenario 2 in certain places, have over a 12 times higher value per acre than your typical suburban residential development. So even though there's more conservation land in scenario 2, the developments that are going on are bringing in a lot more revenue per acre than typical residential subdivisions. And I just wanted to highlight, we go through a lot of the impacts in the report, which is available again on our website, and I will share that. So just to wrap up quickly before sending it over to the panelists, some of the key points in the analysis: under the current status quo, we'll run out of unprotected open space on the island by 2050. And I think one of the key things here is that that's probably really conservative. This analysis was completed basically right before the pandemic, and we've all seen the real estate market just go crazy since the pandemic on Aquidneck Island. The development demand is much higher. So this estimate of losing the open space that's not protected by 2050 is likely, if we continue to see this real estate market quicker than that. One of the other key takeaways is that the current status quo development trends are more harmful to our natural resources like our island's waters. And they also actually provide lower per acre tax revenue than a smart growth and conservation-based vision. And the third thing, which is said a lot being on an island, but we share a lot of the natural resources between the municipalities. We have the same transportation network. Island-wide cooperation and coordination is really important. and regional planning as well to think about development in the future. So that was just a quick snapshot of this analysis. And again, I'll share the information. The rest of the presentation will be on the citizen engagement and land use 101, but we just wanted to share this analysis because it sort of kicked off the interest in the topic when we released this. So we just wanted to share a bit of a summary. I think Scott is in, so I'm going to hand it over to him, and Scott Wolf, the executive director of GrowSmart, who will introduce GrowSmart and the panelists tonight.
Alex, thank you very much. And Chuck, thank you. We're really excited to be partnering with you folks and the whole Aquidneck Land Trust team in this kind of consciousness raising and community empowerment initiative here. I think, Alex, your report and your presentation really lays out starkly the choices that Aquidneck Island faces, and I think most rational people concerned about the island would choose the scenario that conserves a lot more open space and farmland. But getting there requires some focus and techniques and mobilization of residents. And I'm sure everybody who's tuned in tonight is somebody who already is somewhat mobilized. And I think the purpose of tonight's session and the final wrap-up session is to help you be as effective in promoting a good future for this wonderful place as possible. So let me just tell you a little bit about GrowSmart Rhode Island. We're a nonprofit policy research advocacy and land use organization with a training component, and we're committed to making Rhode Island, including of course Aquidneck Island, a place where every person benefits from vibrant neighborhoods and downtowns and town centers, restored and protected natural resources, and a just, thriving and resilient economy. And we think both Aquidneck Island and the whole state of Rhode Island have a very distinctive and precious urban-rural balance. Statewide, Rhode Island is the second most urbanized state in America, but 56% of Rhode Island's land area is forest, and there are 1,200 farms in Rhode Island, and a fair number of those are obviously on Aquidneck Island. So it's a great balance, but it's a delicate balance, and we don't have a lot of margin for error in order to preserve the quality of life we want, in order to expand economic opportunity so more people can take advantage of that quality of life. So one of the major ways we pursue our goals is through training, consciousness raising, information sharing, such as tonight's session that we're partnering obviously with ALT to present. And I want to thank the dynamic duo of Ashley Sweet and Carolyn Wells, who are experienced professional community planners and who are going to be giving you a good overview of how the land use decision-making process works and how you can weigh in effectively in various stages of that process. So let me introduce them to you briefly, and then pass the torch to them. So Ashley is currently a project manager at the environmental and engineering consulting firm Weston and Sampson. She's working with the company's water division on a variety of planning-related topics. She has roughly a 20-year planning career that's included stints as the town planner in Exeter, in Charlestown, and in Hopkinton. So she's been in the trenches and understands the challenges and opportunities at the local level to influence development and conservation decisions. She, I believe, is currently the president of the Rhode Island chapter of the American Planning Association, or if not, is a past president. But Ashley, which is the case?
President-elect.
President-elect, okay. Yeah. And she has a master's in community planning from URI, an undergraduate degree from URI in marine and coastal policy and management. Ashley has represented developers and citizen groups regarding proposed development applications, serving as an intermediary on their behalf. And she's been a longtime advisor and excellent trainer for GrowSmart Rhode Island. And I would add a pro bono trainer. So she's doing that, providing her precious time and talents to us to improve the quality and quantity of life in our state. And now Carolyn Wells is another outstanding longtime community planner and civic leader and an advisor to GrowSmart Rhode Island. Carolyn, like Ashley, has 20 years of professional experience in planning related fields, specifically in the fields of urban and transportation planning, redevelopment, housing, and preservation. She's plied her craft for several different organizations, including the town of Warren. And she's trained and experienced in community outreach and engagement. She's worked closely with diverse residents, neighborhoods, nonprofit organizations, and government entities on a variety of district and municipal plans. And she and/or her planning initiatives have won several awards, including one from GrowSmart Rhode Island, citing the town of Warren's numerous smart growth innovations while Carolyn was the town's planner. So hopefully you now understand what a great team we have here, and I turn it over to them to dive into the meat of the matter. And thank you, Ashley and Carolyn, very much.
Thank you. I hope, can you hear me okay? Everybody can hear me okay? Okay, good.
Yes.
Thank you. So how we usually do this is that I will start us off with the first part of the session, talking about comprehensive plans and land use planning more generally. I'll shift it over to Ashley, and she'll talk about the bodies and boards that approve these plans and review development proposals. And then in the third section, we'll talk about just some tips and ways of approaching planning boards and how people can make their voices heard at the municipal level. So yeah, thank you. So the goal is that you come away from this workshop kind of understanding the flow of how development proposals come before planning boards, what happens during those sessions, and what sort of outputs we can expect from planning board decisions. If you have any questions, again, feel free to put them in the Q&A, and Ashley and I will attempt to tackle them. We hope that you'll come away as well feeling like you're a little more empowered to raise issues before your local boards. And I think that I've covered this slide. Go ahead. Great. So let's dive into it. What is land use planning? Land use planning is both a policy making process, and it's the result of that process. It's the actual policies that we live with. So they're tools that help us approach how we apply our values to the land that we live in, right? In the community that we live in. A lot of it seems very theoretical. Obviously, there are political issues and other issues that can present obstacles and challenges along the way, but understanding the land use policy in the planning process is sort of the first step in making sure that your values are sort of realized. Next slide. Here's the sort of meat and potatoes of the whole land use planning process. If we're talking about a comprehensive plan, which is the plan for each of the municipalities in Rhode Island, and it ideally is a guidepost for all municipal leaders on how, not just how land is used in the city or town, but how the town envisions its own future and how it intends to reach its goals. And so it's a very similar process across municipalities, not just in Rhode Island, but other states as well. The first step is to gather all information that is relevant. That would be all of your current land use mapping, resource mapping, natural resources, social and economic data. So what we begin with all of this stuff. And if we have an older comprehensive plan, we bring that in too. We evaluate how much of that plan was accomplished, and if things were not accomplished, why not? We also gather in our resources in terms of human beings. Who are the people in the city or town who are the stakeholders, the decision makers, the institutional knowledge? Who are the people who can help build the vision for the community? Once we have all of that stuff, we actually have to sort of sort through it, summarize it, analyze it. We usually work with community committees on this, made of residents. And so there's a bit of an educational process in this as well. Both Ashley and I are currently immersed in that process with some of the towns and cities we're working with. And so we distill that data in terms that your average person can understand. And we, at the same time, consult with some of our stakeholders that we found, get some of that input. We might throw out some questions to the community and get a little idea of what they're thinking and what we might want to focus on. And so we start to, from the data and from the community participation, start identifying key issues for the community and weaving that together. We identify really where the gaps are and where the future needs are and where people see themselves going and what they're afraid of in the future. And housing was touched on earlier. That's often a common concern: housing, schools, taxes. We take all of these things in and we try to build the scaffolding of a vision, a set of goals, strategies, and actions. That's that sort of whole piece of this flow that we're in front of. And this plan is both text and infographics and an actual implementation plan. And that is the local comprehensive plan. So that plan is a core document in just about every city and town. It should be the foundation for municipal decision making. It's the basis certainly for decisions that public bodies that are dedicated to land use, the decisions that they're making, and it should be an overall guide to growth. Next slide, please. This is a very long slide, and the summary of what you need to know is that the comprehensive plan it's not just a guide, it's a structure. It sets a baseline of technical information so everybody's on the same page. It creates, theoretically at least, it creates that rational basis for which decisions are actually made. And the idea being that if we have that rational process in place, we are more fair and equitable, we are more orderly, we are making decisions based on data and not emotion or politics. And so, at least ostensibly, we have that clarity and transparency that we hope for government. Next slide, please. The zoning ordinance is different, and it's, you have plans and then you have ordinances, right? You have regulations. The zoning ordinance is really the backbone of a lot of municipal land use decision making. Issues are largely black and white. You're either in conformance with the zoning ordinance or you're not. And that decision is made by your zoning boards. And Ashley will get into that in a little bit. But your zoning ordinance divides the community in districts. Each district has a certain set of allowable uses. And if anybody wants to do something different, they have to petition and offer a reasoning why. It also offers dimensional requirements for each of those districts. And in some cases, it can offer performance standards for uses in the district. We can also add different interests in our zoning ordinance. For example, historic preservation is often built into historic districts, or you can have ecological considerations if you have sensitive waterways. or other design constraints like often water resources, if you have people on septic systems and you have people on private wells. So zoning ordinances do a lot in the community, and it's really important that your zoning ordinance is in conformance with your comprehensive plan. Next slide, please. So the other tool to be aware of are the subdivision regs. A lot of times we call them the rules and regs. And that is, rather than being district focused like a zoning ordinance, the rules and regs really focuses on the development parcel itself and how it performs and interacts with the different parcels around it. If a community has certain standards that it wants to see, for example, stormwater discharge and things like that, that's going to happen at the subdivision regulation level. It's going to talk about how a particular parcel looks in terms of buildings and setbacks and sidewalks and, you know, that sort of lot level design consideration. Next slide. And I alluded to specialized ordinances like in the zoning district, but you don't necessarily have to have it in zoning. You can have standalone ordinances in Massachusetts, their bylaws, and they can deal with a whole suite of information, whether it be conservation or historic districts, renewable energy, trees. They can be built into your general ordinances through the town. So sometimes things are not always housed in the same place, in different places. So you kind of have to know in your particular community where certain regulations live. And usually if you talk to the planner, they can direct you that way. Next slide, please. So I touched on overlay districts. Overlay districts can be particularly important for strategic reasons. As you can see from the map, you can have an underlying zoning district, which may be residential, let's say. But let's say that residential district has it's on a river, and it has some particular constraints in terms of either being flood prone or vulnerable to pollutants. I don't know, whatever the community is coming. They can keep all of the regulations of a residential zoning district and then place on top of it an overlay, which brings new regulations, and any development within that district has to comply with both. So overlay districts, very important. Next slide. So just briefly, we covered what land use planning is, why we plan for land uses, and some of the basic tools, the zoning ordinance, subdivision regulations, and of course the comprehensive plan. So if you have any questions, feel free. If not, I will hand it over to Ashley.
Thanks, Caroline. So Caroline kind of laid the foundation for everyone about what different types of regulations and ordinances we have. And now I'm going to give you an overview of how they actually get imposed and who makes decisions related to each type of those. So with regards to we'll start at the top and kind of work our way down. We have town and city councils. They're responsible for enacting and amending comprehensive plans and zoning ordinances. They have to approve any of those special overlay districts or master plans that Caroline discussed with you. And part of that process is that they get recommendations specifically from the planning board on these types of documents about whether they're conforming with the comprehensive plan. So if the community wants to amend their zoning ordinance, there's an application. It can come from outside. Anyone can apply to amend the zoning ordinance, or it can happen internally where maybe the planning board is initiating an amendment to the zoning ordinance, and that ultimately the decision-making falls with the city or town council. But the planning board is responsible for making sure that whatever is being proposed can be found to be consistent with the comprehensive plan. And their job, and the role they play, is to advise the council on those types of matters. Then we have planning boards. Planning boards are responsible for making land use decisions related to development and subdivision. They are also responsible for their own land development and subdivision regulations. Those are drafted and approved by the planning board. They have to hold a public hearing in order to adopt and amend those regulations, but that doesn't have to go before the town council. They have sole authority over their own regulations. So they will review site plans for commercial development for permitted uses, and they can approve and deny applications for subdivision of land and land development projects. They're also responsible for updating and making amendments to the comprehensive plan. So if the town's comprehensive plan is coming out of date and expiring, it's the planning board or plan commission's job to either work internally or work with a hired consultant to update that comprehensive plan and then ultimately send it to the town council for adoption by the town. They also have the ability to initiate amendments to the zoning ordinance. And as I said before, they make recommendations on comprehensive plan and zoning amendments. Then we have the zoning board. The zoning board is really their sole function is to provide relief to the zoning ordinance in the form of variances or special use permits. They don't actually approve zoning ordinances. They don't amend zoning ordinances. They statutorily can't do that because they are the enforcement body that has to review relief applications under the zoning ordinance. Their other primary function is to hear appeals. They can hear appeals from a zoning enforcement officer, and they can hear appeals on decisions of the planning board. So if somebody appeals a decision of the planning board, that gets sent to the zoning board and they sit as the review body. They do, contrary to popular belief, they do not actually enforce the zoning ordinance. That's the job of the zoning enforcement official. They are the body that, like I said, provides an outlet for relief. You can make application to them under situations where you can't meet the requirements of the zoning ordinance. We also have historic district commissions. They're also enabled under state law, and they have quite a bit of authority when they are established in a community. They're not required, but many communities do have historic district commissions. They have historic district zoning that goes along with these commissions. And their job there is to really use that historic district zoning to preserve architecture, community character, and sense of community in specific historic areas that the city or town has designated. And they have written procedures and standards that they have to follow, and they have decisions that have to be made. So if you want to modify a building in a historic district, there are standards in typically in the zoning ordinance, that establish those district standards, and then you make application to the historic district in the event that you want to modify the outside of a building within one of those districts. So this is a flow chart that kind of summarizes everything we just talked about there, starting at the top with the town council, working your way down through zoning boards, planning boards, and giving you kind of a flow chart of decision making for each of those different types of applications that I just mentioned. So each one of these boards is held to a set of standards in their decision making process. So for instance, we can take a look at the standards for review in zoning. It's enabled in state law. In their standards should be mimicked from state law in the zoning ordinance itself. Standards in the zoning ordinance that have to be met should be in the zoning board's decision making. They make decisions on dimensional variances, and these are instances where, for instance, a structure needs to be closer to the setback line of the lot than the standard calls for. An applicant will go to the zoning board and ask for that relief, and they're required to make certain findings that have to do with the unique characteristics of the property, the surrounding area, that it's not due to, an economic disability of the applicant, that it's not a hardship that's been created by the applicant from a prior action, and that essentially it won't alter the character of the general area or the intent or of the zoning ordinance itself. Zoning boards also issue special use permits. Special use permits are used in circumstances where a use could be allowed in a specific district, but it also has, questionable practices or questionable, impacts that could affect a neighborhood or could affect the character or quality of life in an area. And so it's a second level of review that essentially says, in general, the use is probably okay, but under these circumstances, we want to take a closer look. And so the zoning board is responsible for taking that closer look to issue that special use permit. And again, their findings are related to the characteristics of the property and the surrounding area, that again, the applicant has not kind of created the situation themselves, and that allowing this use will not alter the general character of the area or the intent of the zoning ordinance itself. And then there's the planning board, who, again, as I mentioned, drafts their own subdivision regulations. They're enabled by state law, and there are certain requirements in that enabling legislation. But there's also quite a bit of flexibility on the planning board's part to implement standards for decision making. So some of the required findings that are found in state law, when the planning board makes a decision, first and foremost, they have to be able to say that that decision or that land use that they're approving is consistent with the comprehensive plan. It also has to be consistent with the zoning ordinance, unless that applicant has gone to the zoning board for relief as part of their review process. They have to find that there's no significant environmental impact. They actually can't create lots with physical constraints to development. So for instance, they can't create new subdivision lots that say don't have frontage on a street and can't get access. They have to meet certain requirements about physical design and public and design and improvement standards and construction and improvement guarantees. Sometimes there can be requirements for dedication of public land or open space, or there are phasing requirements in a subdivision. And that's where the town can have some flexibility in implementing some of those requirements for subdivision. So there's a couple of different types of development processes under the subdivision regulations. There's conservation development. And this is something that's enabled, but is not required. So that some of the communities have adopted the concept of conservation development, which essentially takes a step back in the design process and looks at the land first to find out, what are the physical characteristics of the land that we want to preserve first and foremost, and setting those aside, and then taking the overall allowed density of a particular lot and maybe compacting it into a smaller area to reduce the physical footprint of the development, and then preserving those natural features on the rest of the site. There are residential compounds. This is a trade-off scenario between the municipality and the applicant, where you have a more rural type of residential subdivision. You get fewer infrastructure improvements. Typically, the biggest trade-off is the road. The applicant will get to create a road that's not necessarily built to town standards. It can be kept as a private driveway. So the town gets less dense development and doesn't have another roadway that they have to maintain. And then we have land development projects. These are projects that have multiple buildings on one site. They're typically a mix of residential and non-residential uses. So we have two different types of subdivision when we're talking about dividing up land. We have major subdivisions, which consist of 6 or more lots. They're required to have 4 stages of review. They begin with a pre-application conference. This is an informal meeting with the planning board. It's an exchange of ideas between the applicant And the planning board, the applicant will present a conceptual design. The planning board will respond. There are no decisions that are made. Nothing is binding on the planning board or the applicant. It's kind of a free-flowing back and forth so that the applicant can get a better understanding of what the planning board likes and doesn't like. Once they've gathered that information, they come back at a master plan stage of review. This is still considered a conceptual stage of review, despite the fact that it's called a master plan and you would think it's the be-all end-all. It's a conceptual engineered design. Once that gets an approval before the planning board, the project is considered vested and the applicant disappears for a little while and goes and gets their state permits and refines those engineered drawings and comes back at a preliminary plan stage. Again, ignore the name. It's counterintuitive at preliminary that you have hard engineering and state permits, but this is what they chose to name these stages. And then there's final plan review, at which point the planning board is making sure that conditions that are imposed on the applicant at either of the two previous stages have been met, and that all of the drawings are finalized, and then they're recorded in the land evidence records of the town, which essentially creates these new subdivision lots. We also have minor subdivisions. This is 5 or less lots. And there are 3 stages of review required here. Again, a pre-application conference, having an exchange of ideas, preliminary plan being the hard engineering stage. State permits are required at that point, and the plan undergoes a pretty detailed review by the planning board. And then we have final plan stage of review, where depending on the complexity of the project, either the planner in the office can approve the application with the authority of the planning board, or the application goes back to the planning board for a final approval. One thing to understand, I think that sometimes is a misconception, is that the planning board really has standards under which they have to make these decisions. They can't be based on opinion. They have to be based on whether the plans comply with the regulations and whether the applicant the land is zoned for the proposed use, and if the application is consistent with the comprehensive plan. So this is a difficult slide to read at this level, but this is kind of an overview, something you can take a look at if you're interested in learning a little bit more about the stages of review. Every time you see one of those little clocks, that's an indication that there's a time frame in which decision making has to happen. So when we're dealing with minor subdivisions and major subdivisions, we're talking about the requirement to certify applications complete within a certain time frame. When an applicant submits something, the administrative officer, which is often the town planner, has so many days, depending on the type of application, to say, yes, you've met all the requirements of the regulation. We can essentially check the boxes and say you submitted all of the required materials. And then that time clock then starts another time clock, which is decision making. So then, depending again on the type of application, the planning board has a certain number of days to hear the application, hear the applicant's expert witnesses, ask their questions, hear input from town officials, whether it's the planner or sometimes the police chief or the fire chief. We'll look at safety issues, and then the planning board has to make a decision within a certain number of days. So I was asked to speak to you a little bit about solar, understanding that has been a topic of discussion in Rhode Island now for a couple of years. Solar can be looked at in a couple of different ways. There are proponents of solar who talk about its impacts with climate change and its environmental benefits. It also has some economic incentives, but there can be a problem when your zoning ordinance doesn't clearly define how those applications should take place or where specifically solar installations are appropriate to happen. And so In Rhode Island, what we saw several years ago was a land use essentially that not really very many people understood or even knew about. And then all of a sudden, with some state incentive programs, we started seeing large solar applications. And a lot of these solar applications were in places where they were not highly desired. So they were adjacent to residential areas, they were in heavily forested areas, and a lot of communities struggled with how to regulate these. There is a common theme that if it is not defined in your zoning ordinance as a use, your zoning official has two options. They can say it's not in the zoning use tables and therefore it's not allowed, or they can find a use that is similar and they can say that it is considered allowable under this particular use. So a lot of communities did not have solar in their use tables. They didn't have it defined as a use. And in some cases that ended up being circumstance where a use like, say, utility, which is a pretty generalized use, was used to say, oh, well, utilities are allowed in X, Y, and Z district. We're going to say a solar installation is allowed under a utility, and therefore this is where it's allowed. The problem with that being is that there were a lack of standards that went with it, and it was a use that wasn't widely understood. And so a lot of communities grappled with how to regulate these, where to regulate them. And it took us some time to catch up to that and figure out, what were the issues with this use that we needed to regulate, where were the places that they were most appropriate. And there are ways to write incentives and standards into your zoning ordinance. A lot of communities wrote solar ordinances specifically that talked about where these uses were allowed, what the standards for development were, and then incentivized solar installations in particular areas by allowing, larger size of solar installations. Say if you were using a previously disturbed site or an old gravel bank or on a landfill, as opposed to clearing forest land next to a residential neighborhood. So there are mechanisms that you can use and standards that can be written into your ordinances for solar, as well as other types of uses when a community wants to specifically target when and where those things happen. So that's the end of part 2. We covered who makes land use decisions and what those processes are. So if you have any questions, you can put them into the Q&A and we can look at them. Do you want to look at them at the end, Caroline? We can finish this. We have one question in there now. I don't know if you want to.
Here, we'll take a look since we're on the topic. It says, what can citizens do to stop solar arrays going in next to residential properties and reducing home values when the planning board refuses to deny master plans despite pleas from the abutters to do so, and refuses to use the power given to them per the solar ordinance to add additional provisions to ensure minimal impacts to nearby residents?
So, I think the best a community can do from my experience is to make sure that you have a really solid solar ordinance that addresses those impacts and is not kind of wishy-washy in the sense that it says that the planning board can do this, but that the planning board shall do this. Imposing, pretty hefty buffers between residential areas and solar arrays so that visual impact is much less of an issue. I hate to say it, but when a planning board doesn't follow their own regulations, there's not a whole lot you can do unless you want to take an appeal to their decision, which is unfortunate, but sometimes that's what has to happen. Solar has, less so now, but initially was a pretty contentious land use. I think a lot of municipalities have worked out the details. They've had a chance to take a breath and to draft solar ordinances that try to do their best to minimize the impacts. Caroline and I will both kind of go over what you can do as an individual. you know, when you have an application before the planning board and you want to participate in the process. So maybe that will also help answer that question when we get there.
Yep. Let's move on to part 3, and we can keep that in mind as we go forward.
Okay.
So there are a number of ways of making your voice heard. There are opportunities to talk directly to boards during public hearings. To differentiate a public hearing from a public meeting is something that people should always understand. All planning boards have regular public meetings and special public meetings for certain purposes, but they're required to have public hearings for plans at certain approval stages, for both the creation of a plan and approval of plans before the board. Sorry, I'm glitching tonight. Public hearings are, the public has a right to be heard. And we'll talk a little bit more of that in a couple of slides, but just make sure you understand the difference, because public meetings often don't allow public comment. State law requires that those hearings be recorded so that you can view them, often on demand nowadays. And that testimony at those meetings is usually with the help of a stenographer, captured and transcribed. So next slide. So if you want to figure out where the regular meetings are, every board and commission must file with the Secretary of State their agendas. You can go to the Secretary of State's website and get notices from the Secretary of State with your email, so that you can know whenever a new agenda is filed for a particular board or commission. Next slide. What you'll get is an email that looks a little like this, and at the bottom you can see it says January 1st, 2020. That would be an agenda. You could click on that and you'll see everything on the agenda. You can also, in many communities, go to the town or city website, and often you can get the whole packet. So not just with the agenda, but all of the backup matter, and see what the planning board is seeing. Next slide. A public notice has to look like this. It has to have this information in it in order to be a valid public notice. So you'll see that it has to have the public body, the date, the time, the location, details of the agenda items. It's not usually sufficient to just give the title of the application. You actually have to describe what the applicant is trying to do. They talk about, not all planning boards have an adjournment time, but more and more, many of them are, because they don't want to go till midnight. And then accessibility information is at the it should be at the bottom of every public notice. Slide. So as I discussed, a public meeting is something where the routine business of the board is conducted. It's always public. You can always go and attend. It is often at the discretion of the chair whether they will take comments. Sometimes they choose to, and sometimes they don't. A public hearing is a different matter. As I said, the public can always speak for or against an application. And we're going to talk a little bit about the best way to do that. Next slide. So again, the public hearing is designed to collect public input. It's about putting the application, presenting it to the public, and getting public comment back. So again, you'll see that in the newspaper, but if you sign up for agendas, that's usually the best way to understand what's coming down the pipeline. There is a presentation by the applicant, and then there's a period where the planning board can ask questions. The public will be invited to comment or ask questions as well, and that often is the case. And the chair will usually manage that process and allow for any rebuttals from the applicant. If somebody has made an allegation that's incorrect, it allow them to delve a little more deeply into some technical information if it seems like things are unclear. Ashley, feel free to chime in if I'm missing something. Okay, next slide. There you go. So as I just said, staff will usually frame up an agenda item. In most cases, staff has given what they call a director's report to the planning board, which is their professional evaluation of the application, its deficiencies, whether it conforms to town regulations. They may raise some questions that they will advise the board that they might want to pursue. And so that's why it's helpful to get that full packet, because if you can read that report, it'll give you a lot of insight into what's about to be said. At the meeting, the applicant will provide their testimony. They might have expert witnesses come up. They may have testimony from other staff. Often public works directors are called up to talk about any impacts to municipal facilities or services. And then the public can bring its opinions in. It says stakeholder opposition, but it's also there can be people who are in support of a project. And all of that testimony is gathered. So when the public is invited to come up, the person must say their name and their address, and then their opinion. And then, as I said before, the applicant will have the opportunity to address some of the issues that were raised by the public. And then the board will close the public hearing at that point.
So I just want to use this opportunity to kind of use the solar situation as an example. Depending on the review process that the town has chosen for an application will depend on whether or not there is an opportunity for a public hearing. So for instance, in a lot of communities, solar ordinances, they've used the major land development process to address solar installations. And in the major land development and major subdivision processes, there's going to be two opportunities for public input. At the master plan stage, there's what's called a public informational meeting. That's not technically a public hearing, but it's treated very similarly to a public hearing in the sense that it requires notification in the newspaper. Abutters to the project have to get specifically noticed by mail. And there is an opportunity for the public to comment and make their voices heard. That's at the master plan stage, which technically is the conceptual stage of review. So for the person who asked the question, how do you get them to pay attention to abutter, concerns? That's the time to do it. I can't tell you how many times I've gotten the phone call of, we have an application in our neighborhood and we need an expert witness, and we've hired an attorney, and we really want to, we want to make a presentation to the planning board and put you on as an expert witness, but they're at preliminary. Well, the project's already vested. And so we're kind of running after the project at that point to try to catch up to where the applicant is. And so master plan is really the best place for you to come in as as a resident to either voice your support or your concerns with a particular application. The preliminary stage of review does have that public hearing requirement. Again, it's got to get noticed in the newspaper. Abutters are going to get notified by mail, and then there is a formal public hearing process that happens. Again, it's a good opportunity to voice your concerns, but we're already talking about a vested project. So the ability to make an impact is somewhat lessened at that stage of review. Not to say that you shouldn't do it, but if you're paying attention to projects and you're aware of what's going on in the community and you can catch something at the master plan stage, that's the great opportunity to really kind of involve yourself in the process. And you can do that by providing your own layperson testimony. You can do that by matching expert testimony with other expert testimony. The applicant is going to bring in traffic engineers and landscape architects and all other, they might even bring in a planning expert. And so there's an opportunity there for anyone who's a concerned resident or a citizen group themselves to kind of formalize themselves and to be able to hire their own experts and counter some of the testimony that's put on record at those stages of review.
Yeah, we can, Yeah, okay, we'll have this slide. I was just going to go into a little more detail. One thing that I think people think when they present before a board is that if they're emotional, if there's a lot of people, that's going to sway the board. It might not. It probably won't. The board has certain criteria it has to meet in making its decision. It's best if you understand what that criteria is and how you can articulate your concerns directly related to the decision that the planning board has to make. So to say we don't like it, to say it affects our property values, this is not anything that the planning board can hang its hat on. What you need to do is look at the comprehensive plan and know it and find in there where it says that maybe the solar array is out of character with your comprehensive plan and what you're, you've got to draw a direct line between what's happening to you and the decision that they have to make. And if it's too loose or vague, it's not gonna be persuasive. So let's just look at some basic tips. Obviously, you have to identify yourself. They'll ask you where your address is because they're going to weigh how interested you are in this particular opinion. If you live in the next town, then you're not right as vested in the outcome. As I just said, back up your opinions with facts and framing it according to the land use decisions and plans that are already in place. Are they in keeping with prior decisions? Are they in line with existing plans and regulations? Those are the things that you need to think about. Be brief and be polite. Those are the things that I can say. And I'm not, when people get up there and they're rude and they're, obviously on the offense, they're not being heard. So I think that's obvious. Next slide.
One example to give you that I often use, and this is no offense to any traffic engineer, but I've never heard a traffic engineer say for an applicant that they're going to make traffic worse. So the idea behind that being, you live there, you know how bad traffic already is. Your personal opinion is that obviously this development is going to make traffic worse. The best and most impactful way to express that to the planning board would be to provide them with not just testimony, but pictures. I think you can use visual aids a lot in these situations. If you can show, this place floods all the time, and what they're doing is probably going to make this flooding worse. Show them pictures of that flooding. Give them these concrete examples that they can kind of grab onto, as opposed to, like Caroline was saying, just saying things like, well, I don't like it, or, I don't want a solar array on this property because my kids ride their bikes there. That's not your land, and that's not a good enough reason for them to say, well, okay, well, we won't approve a solar installation so your kids can continue to hike on private property. Those are not arguments that are going to sway the planning board. Those are arguments that if they deny an application based on those, the town is going to end up in court on that. So they need concrete examples, like Caroline said, to tie it back the best way you can to the standards that they have to make decisions on. So those, again, they're tied to the comprehensive plan, they're tied to the zoning ordinance, they're tied to environmental issues. So, any way that you can draw those lines for them, you can make those connections for them, they're gonna listen more so than to these kind of impassioned pleas of, we just don't want our neighborhood to change. There's nothing there for them to use in their decision making.
Oh, and I was going to add, and I'm glad we have this slide. It is always good to back up your testimony with written bullet points. It doesn't have to be a letter. It can be a letter. Usually you'll submit it to the town planner or the administrative officer, preferably before the meeting. So it can be included in their packet, that every planning board member will get a packet, or it'll become part of the record. And as I said, keep your points clean and straight to the point. But if you say the same thing in the meeting and you have already submitted a bullet point, just description of what you're going to say, that will give them something to hang their hat on and remember.
So, oh, I'm sorry, keep
Go
going.
ahead.
I thought, no, is this still, this is the last, I just want to make sure we have some time for questions, but keep going.
Yeah, well, this has got to be the last few slides. And if you have to miss a meeting, but you want to know, you can always view the file. You have to often fill out a form, but every public record in the planning office should be visible and available to you with the correct procedure, and you contact the town clerk with that procedure. Very few things are shielded from the public. Usually it's like social security numbers and attorney-client privilege and that sort of thing. But for the most part, the public record is completely visible to you so that you can actually read through and see how the process works. Next slide. Yeah, so this is a summary slide. Your planning board approves your subdivisions and your land development projects. They provide advisory opinions to the zoning board or for special use permits or variances. They're not necessarily overseen by the planning board, but the administrative officer coordinates all of their activities. And applicants usually have a pre-application meeting with what's called a TRC, a technical review committee, which is often a nice conversational meeting with the applicant so that like real issues can be aired out before they go public. The zoning board reviews applications for special use permits and variances, and they are administered by the zoning administrator, and that person is often a town planner and assistant town planner. So we're all done with section 3. We talked about meeting notices and how you can best participate with one of these boards. We talked about the 2 types of meetings, the public meeting and the public hearing, and the best way to speak before the boards. So let's move to the question.
Thank you, folks. Excellent presentation. I think there's at least one question in the chat. And Jillian, you're going to help us with this section?
Sure can. So I think we pretty much addressed the first question, which was about the solar arrays. The next question is, why is it on the residents to hire experts and not the town to protect residents from misinformation by the development companies?
So
Good question.
I would say, you know, it's not, I don't want you to think it's always on the residents, and it's not necessarily about misinformation from development companies. I mean, the planning board is faced with an application for development. You know, standards are written in a way that they try to protect the community. So, you know, for instance, there shall be no environmental impact. Well, they're going to show up with a team of experts that's going to stand before the planning board and present expert testimony that says we're not going to have any environmental impacts. If the planning board questions that or does not necessarily believe those statements, they have alternatives, they have options. Many regulations have it written into the process that the planning board can hire their own expert witnesses. And so we would encourage planning boards in the instance where something is unclear or they don't necessarily wholeheartedly believe the developer's expert testimony, they can bring in a neutral party that's paid for by the applicant, chosen by the planning board, to essentially do a peer review and look over that traffic impact analysis or that stormwater management plan, and do a peer review of it. If the town is not moving in the direction that the residents are comfortable with or they believe is the best approach, you know, then it would fall on the residents to kind of organize themselves and decide whether or not they feel like they need to take part in the conversation and hire their own experts.
There also is, Ashley, as you mentioned before, there is an appeal process. Can require some expenditure of both time and money.
Yes.
And I know as a member of the zoning board in Providence, we get a lot of appeals from decisions made by planning boards and sometimes decisions made by zoning officials. And I also know that some of our decisions that some parties don't like get appealed to the Superior Court. And I don't know now, and is there an opportunity if a planning board decision is appealed to the zoning board and the zoning board rules in favor of the planning board, is there then an opportunity to push it up to the Superior Court or not? I don't know that detail.
I am not an attorney, but I do believe that you can appeal, if an abutter, could appeal that decision also. It's not an unappealable decision.
Right.
It's not the end of the process.
Right.
The next
Jillian,
question actually kind of complements that one, asking, as you described, the public comment process is clear when it relates to specific projects or applications. What is the best way to get the planning board to consider long-term and strategic development, such as mixed use or higher density development? So I think that means not based on a specific project, but perhaps for the comprehensive plan or
That's
another.
really where your comprehensive plan comes into play. Comprehensive plans can be amended 4 times a year. So you don't have to wait for a big overhaul necessarily to try to impose these kinds of things into the comprehensive plan, remembering that the comprehensive plan is policy setting, really, and that everything trickles down from there. So if there's a desire to, say, rezone certain areas of town for mixed use development, you really kind of need to start at the top and make sure that your comprehensive plan identifies that as a goal, and that your future land use map shows that area as a mixed use area. And then you would, or simultaneously would be amending the zoning ordinance to do those in concert. You can't do them kind of separated from each other, or you can't do zoning and not the comprehensive plan, because then you have that inconsistency issue.
Yeah,
Caroline, I don't know if you want to.
I would also add, unfortunately, planning boards are often at the end of a planning process. And if you have an interest, say, in a particular area that you want to create a mix of uses or higher density, you really should start with the planner, the staff person. They're the ones who do the work. They're the ones that do the thinking. The board just acts. They're not planners. They're just people. They're just regular people doing a job. But planners are the ones who do a lot of the thinking behind the scenes. They understand the political atmosphere that they work in. So if you have an idea, and I've had many residents come to me in my planning office and say, this lack of ability to have a mix of uses, or the lack of ability to develop in this area is creating a real problem for me. How do I resolve it? And Ashley is totally right. It does happen at the comprehensive level, and it doesn't happen quickly. But what does make a difference is if you find other like-minded people in your town, particularly if they're business owners or property owners, and you band together and you start creating a vision for this area and building political will, that's how you get things done. And it's not quick, unfortunately.
Yeah, and that Caroline brings up a good point. The planning board and the zoning board they're volunteers. They typically, if they do get compensated, it's not very much. They have full-time careers and lives, and they're really doing this on a volunteer basis. And so they're not infallible in their decision-making by any means. And, they're going to rely on hopefully they're going to rely on their planner and the other staff in town. But they're also, you have to understand, in some circumstances, specifically with complex projects, and we saw this a lot with solar development because it was a land use that nobody really understood. they were presented with pretty complex projects where they only had the expert knowledge of the developer in front of them, and did not have that kind of offset of other expert knowledge that was more, was more neutral. So unfortunately, because of that dynamic, sometimes it does fall on the backs of residents who are unhappy with the way a process is going to step in and insert themselves in that process and hire their own experts to say, wait a minute, planning board, you need to hear the other side of this.
And in fact, Ashley, what we at GrowSmart Rhode Island have tried to provide some expert guidance through our staffer, Scott Millar, to some communities and community groups with concerns about solar siting, but our bandwidth to do that is somewhat limited, unfortunately.
Sure.
I will say that while I think Ashley in Exeter, where you were the planner, and some other places, the storm, the solar storm or the solar surge, storm may be too negative a term, but the solar surge has died down. But in other places, it seems to be heating up. And I know in the last month, we have gotten inquiries about proposed solar ordinances and concerns about the proposed solar ordinances from residents of Portsmouth, Tiverton, and Warwick. So there may be kind of a second phase of this solar anxiety and solar surge going on.
And I mean, the only good thing I can say about it is this time, we know a lot more than we did the first time around.
Right.
And hopefully we've learned some lessons. And I think there are some really good solar ordinances out there that can be looked at to help a community kind of guide the development. And, another thing to understand is that these zoning ordinances and subdivision regulations and comprehensive plans, they're living documents. They have to continue to evolve with different land uses and different, basically the wind of change, they kind of have to follow along with it. And what we saw happen a lot, and I keep using solar as an example, but I think it's a pretty relevant one, is that there's still a lot of comprehensive plans that don't even have the word solar in it a single time. Right. So there was a big, that's a difficult and challenging, circumstance to be in, and also zoning ordinances that didn't have the word solar in them. And so kind of happened at the will of the zoning official, whether or not this land use was something that was permitted or prohibited or what. And I think a lot of that decision-making did not, and not as a criticism, but did not really see the impact of what that was going to produce in a community. And until it really started happening, it wasn't well understood. And by that time, it was like too late to put the cat back in the bag.
Right. Jillian, are there other questions you're fielding?
One last short question. Is there a time limit to when the meeting minutes should be available to residents? Ours is usually 30 days or more.
I believe it's 30 days, isn't it, Caroline?
Yeah, I believe it is too.
And they don't have to be approved. They can be draft at that point. They just have to be made available, because often what will happen is a planning board won't have another meeting necessarily in time to approve the set of minutes from the previous meeting. So as long as they're draft minutes, they can go up and be posted. They just get posted as a draft. And then would get amended and replaced with the finalized minutes once those are approved.
And I'll just add, the Secretary of State is good for agendas. It's not so good for minutes. People are supposed to be putting minutes up there, but they don't. So if you find that you can't get them, you need to call the planning office. If they have those draft minutes, again, all those documents are public. So, they can send it to you and it can have draft on the cover, but it's still a public document.
Great. So I think we're getting close to the end of the session, and I want to turn it back to either Chuck or Alex in a minute. But before that, I just wanted to make a couple of observations and provide a few points of information. First of all, I want to thank Ashley and Carolyn for another terrific job, and your candor, your thoroughness, your insights are all deeply appreciated. And I also want to clarify, I said you did work for us pro bono. That's true. But I don't want people to think that all the work you do is pro bono. You've got to make a living, and you are consultants, and you do training and consulting on a paid basis as well. And you both, as I believe you're both currently working for Weston and Sampson, which is one of a number
Correct.
of really good planning and engineering and environmental consulting firms in our area. So I just wanted to clarify that about you folks. And I also wanted people to know that there is a state land use reform commission that has just been established and that could be making some significant changes in a lot of the structure and process of land use decision-making that we've just outlined for you today. I don't think it's going to happen overnight, but it is something for those of you really interested in this area of government and community planning to keep an eye on. Oh, and then I maybe this was already covered, but I believe we're intending to send the presentation of Ashley and Carolyn to all registrants. Is that right? Jillian, I guess that's a question for you.
Yes, I will share it as a PDF and with ALT, who can then share it with the registry.
Great.
So I just
So,
noticed there's one more question that came up, if you don't mind. It's a quick answer. The
Okay,
question is,
okay.
what's the process for updating the solar ordinance? So anybody can amend an ordinance. You can propose an amendment as a citizen. You can ask the planning board to propose an amendment. Typically, the zoning ordinance is written by the planning board and the town planner. Usually it's written by the town planner and it's reviewed and approved by the planning board and then sent up to the town council. So it can be a movement from the community. It can come from within the planning department. And then it goes to the town council for public hearing. The planning board would provide an advisory opinion.
Great. So I hope one thing you've all gleaned from this is there are a number of different points of access and influence potentially in this process. And I think you've gotten a lot of good pointers on how to put your best foot forward. So with that, Chuck, I turn it over to you to close out our session.
So I wanted to thank all of the participants for coming. I wanted to thank GrowSmart Rhode Island and staff. Scott, great job. Ashley and Caroline, thank you. I wanted to remind everyone that there is an advanced workshop on more innovative zoning methods on October 20th, 2021. It will be on Zoom, and you can sign up either through GrowSmart or ALT. We will be sending links out to the community on that. So please sign up for that. And I wanted to lastly, again, thank the Van Buren Charitable Foundation for funding these workshops. I hope it was helpful to all of you. And good night. Thank you.
Thank you, everybody.
Good night.
Good night.